3 years after his death, Raymond's family is fighting over his estate in Massachusetts' highest court. Raymond had remarried, but he did not update his will.
To somebody else. This was a will he had done 15 years before he died, where he didn't even know this person at that time, and just left that old will in place, never having done a new will. So to try to
Raymond's will is still valid, even though he had remarried.
Doesn't marriage revoke the will?
It used to, Your Honor. Now it
Okay,
doesn't.
I'm out of date then.
Can I ask you to walk?
Raymond's surviving spouse filed a waiver of will in Worcester Probate Court, launching years of litigation. Waiver of will and surviving spouse's elective share are potential probate problems you can plan to prevent. In Raymond's case, his will left equal shares to his 4 children by a previous marriage, but nothing for the surviving spouse. State law allows the surviving spouse to set the will aside and elect to take a spousal share. But the state law of wills that explains the spousal share gets everyone confused.
I just can't follow this statute, I'll be honest with you. Can you walk me through? I'd like to go through the exact language itself. It goes, I'm reading from the statute, except
if there are children or grandchildren and the estate is worth less than $75,000, the statute says the surviving spouse gets 1/3 of the estate. Raymond's estate was worth more than $75,000, so spouse gets 1/3 of the estate for life plus $25,000. The problems begin when people can't agree on how to handle the spouse's 1/3 lifetime
She gets
share.
the first $25,000, you agree, right?
No, I don't agree. That $25,000 is paid for from that 1/3 share in which he or she, the surviving spouse, is interested in.
She doesn't get $25,000. She gets income off of $8,000 and income off of, no.
She's paid the excess for life, excuse
Okay,
me.
so now we have $400,000 in realty. What happens to that? I want to
parcel?
keep it simple, just $400,000.
Settling an estate can be kept simple. On the other hand, estate litigation in probate court is costly and complicated.
So she could get a big nothing out of this, is what
She
you're saying.
could get a big nothing out of the real estate.
Okay.
Correct.
Wow, what a mess.
The mess of probate litigation can be avoided with estate planning. A prenup or postnuptial agreement can be written to cancel a spouse's right to waive the will. The best estate planning, though, provides sufficient financial support for the surviving spouse. With a living trust which becomes irrevocable upon death, we plan to protect a surviving spouse and preserve assets for other members of your family. Like a will, a trust is also subject to the state statutory share law. But if sufficient support for the spouse is included in the trust, we eliminate any need for a surviving spouse to go into probate court demanding a spousal share. Your trustee can manage all the assets, including real estate, with no probate court involvement. Update your plan now to save expense for your family in the future.